A very good morning to all the present people over here. Our guest for today, Honourable Mr. Justice A.G.Uraizee, former Judge, High Court of Gujarat, our Dean, Dr. Mayuri Pandya, and our Vice Director, Dr. Sneha Shukla. My dear participants and all the students, I welcome you all to the e-platform of Faculty of Law, GLS University. Before today's event, let's take a moment to remember the divine wisdom to shower the blessings on all of us present.
शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोस्तुते दीपज्योतिर्नमोस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः
Socrates truly says that a judge's duty is to render justice in a larger sense. Rendering justice means giving every person his or her due. All those entrusted with power to govern, power to legislate, power to adjudicate, and power to punish or reward. In a sense, rendering justice in the context of judges, rendering justice means speedy, effective, and competent adjudication of disputes and complaints fairly and impartially by the law, tempered by equity, equality, and compassion wherever required and permissible. After due hearing, in other words, the justice needs to be done cautiously, wisely, soberly, and impartially. Considering the importance of judgment writing skills, today we have gathered here for the expert lecture on judicial eloquence, the art and science of judgments by Honourable Mr. Justice A.G. Uraizee, former Judge, High Court of Gujarat. I would now like to invite the backbone, the powerhouse of Faculty of Law, GLS University, the Dean, Dr. Mayuri Pandya, for her welcome address. Ma'am, over to you.
Thank you, Neha. Honourable Mr. Justice Uraizee, sir, my colleagues, all the participants who have joined virtually on this e-platform of the GLS University e-platform. I welcome all of you to this virtual judgment writing competition announcement and the special lecture on the judicial eloquence and especially the writing of the judgment. First of all, I congratulate each and every participant who have participated in this event. Without you, this event was not possible. And this is the testament that your passion, the passion for love, for law, and your love for the justice. So this is the testament, your participation. Whatever the result may be, each one of you you have already succeeded by participating. So I congratulate each one of you and welcome you on behalf of Faculty of Law, GLS University. All of you, we are thankful to Honourable Mr. Justice Uraizee, despite his so much, he's very busy schedule. He has spared special time, and that also is the testament for his commitment for the legal education and for the future generation of the country. All the participants here to appraise Honourable Mr. Justice Uraizee sir that here 35 institutes have participated, and across the country 18 states are representing, and out of them the best of the three participants will be awarded the second runner-up, the first runner-up, and the winner team. So again, I welcome each and everyone who have joined on this virtual platform of GLS University, and wish you all the best and all the good luck.
Thank you so much for the warm welcome, ma'am. I would now like to invite Dr. Momita Das, Assistant Professor, Faculty of Law, and co-coordinator of this event, to formally introduce the guests for today. Ma'am, over to you.
Thank you, ma'am. It is our great privilege to introduce today's distinguished guest, Honourable Mr. Justice A.G. Uraizee, former Judge of the High Court of Gujarat. His Lordship hails from a family with a distinguished judicial legacy. His grandfather served as a Munsif in the erstwhile state of Bombay. His father was a district and sessions judge, and his paternal uncle also served in the judiciary, reflecting a lifelong association with the justice system. His lordship completed his academic training in commerce from Gujarat University and obtained his LLB special from MS University, Vadodara. Enrolled at the bar in 1983, he began his legal practice at the City Civil Courts, Ahmedabad, and the High Court of Gujarat. In 1994, his lordship was appointed as Assistant Government Pleader and Additional Public Prosecutor in the High Court of Gujarat. Subsequently, he joined the judicial service as a direct recruit judge, district judge, and held several key positions, including the district and sessions judge, principal judge of the family court, member secretary of the Gujarat State Legal Services Authority, and registrar of the High Court of Gujarat. His lordship was elevated as an additional judge of the High Court of Gujarat on 4th May 2013 and took oath as a permanent judge on 1st April 2015. A trained mediator, his lordship has also contributed extensively to mediation and judicial training programs across the state. We are truly honored to have his lordship with us today. And now I would warmly invite the guest for today, Honorable Mr. Justice A.G. Uraizee, former Judge High Court of Gujarat, to share his expertise and wisdom on the art of judgment writing with all the participants and students who have joined us on this platform. Sir, I'm sure today's lecture will enrich them with understanding of how and in what way the judgment needs to be written and understood. Thank you so much, sir. Over to you.
Good morning to everyone. Dr. Mayuri Pandya, Director of the Gujarat Law University Faculty of Law, Deputy Director and other who have taken pains in organizing this competition, dear participants. At the outset, I thank the GLS University for making me part of this competition. And normally, the impression is that the legal education imparted to the student is aimed at training them as a good lawyers. But this initiative on the part of GLS University to organize a judgment writing competition is a very welcome step, because in a sense it also trains the students. It aims to train students in the art of writing the judgment, and therefore in my view, the my lecture is aptly captioned as the eloquence of art of writing and the writing and science of writing judgment. Dear students, uh, we can say that judgment writing uh, is in a sense a very serious uh, job of a judge, because judge delivering the judgment, in fact, he speaks through his judgment. Judgment, in my opinion, is nothing but an expression of opinion. And how eloquently a judge expresses his opinion on the basis of the evidence of the facts of the case in the trial court, and the evidence led, oral and the documentary evidence led by the parties in support of their respective claims. So judge has to consider first the consider and appreciate the oral and documentary evidence, and then apply the law applicable to the facts of the case and the case law, that is the judgments of the High Court and the Supreme Court, to arrive at uh, his conclusion, final order. We have to keep one thing in mind, that I may be a very proficient in a particular language, because the trial court judgments normally are in the vernacular language, while the judgments of the High Court and the Supreme Court are in English. I may be very proficient, expert in either the vernacular language or the English language, but I must keep the litigant as well as the other lay person who might read the judgment in mind while writing my judgment. What I want to say is that I should write my judgment in a simple language so that it can be understood by the litigants or the person who reads it for, say, an academic purpose. Using very flowery or bombastic language does not serve the purpose. On the contrary, it confuses the litigant. We are writing the judgment for the litigant, who should understand what the judge has said about his evidence and the law, how he has analyzed the law to either accept his case or reject his case. So first of all, we should keep in mind that the language which we use in writing the judgment should be simple. I have gone through the compilation of all the 35 the judgments of the participant, and I am very happy to note that all of you have written your judgments in a very simple and lucid English language which can be understood by anyone. So this should be the correct approach for writing a good judgment. Secondly, a judge should have a good command over pressy writing. Why pressy writing is important? Because you see, the pleadings many a times runs into many pages. Facts of the case plaintiff would present in a very lengthy manner, and likewise the defendant or the respondent would put up his case to counter the case of the plaintiff in a very lengthy way. So the job of the judge is to summarize the case of the plaintiff or the claimant or the petitioner and the defendant or the respondent in a very concise way without missing the heart of it. The real controversy or the dispute between the parties should not be missed while summarizing the facts of the case. What I have seen in the recent time is that many, not all, but some of the judges, they simply reproduce the entire plaint as the facts of the case and the entire this written statement or the reply of the defendant in their judgment, thereby making the judgment very lengthy and verbose. The parties are not interested in the lengthy facts. They want to know the summary of the facts and the findings of the judge as to whether their claim is accepted or not. So, first attribute of a good judge in writing a good judgment is that of preciseness or conciseness of the facts of the case. Thereafter, on the basis of the pleadings of the parties, judge has to find out the dispute. What are the issues on which the parties are at variance? The plaintiff or the petitioner would have said many things in his plaint or the petition, and from these facts, the defendant would accept some of the facts stated by the mm, uh, plaintiff or the petitioner, and may dispute the some of them. So the admitted facts, should not devote much time to the admitted facts, but then he has to find out the the dispute, the points at which the parties are at variance. So this is a very serious exercise which the judge has to undertake. He has to judge has to read the entire pleadings. Pleadings include the plaint or the petition and the defendant's reply or written statement or the respondent's reply to the petition. So after reading both, he has to find out, judge has to find out as to on what points the parties are at agreement, and then most importantly, he has to identify the issues at which the parties are at dispute. So, the judge has to then formulate the issues in the matter case, and then he has to incorporate those issues in the judgment. And on point wise, as far as the judgment of the trial court is concerned, the judge is required to record his findings in light of the oral and documentary evidence regarding the issues framed by the court. Say the one of the issues is whether the if it happens to be a litigation between a landlord and tenant, then the first of all, and the issue of areas of rent is there, then the plaintiff would say that the defendant is in arrears of rent for certain months, which entitle him to recover the possession of the rented premises from the tenant, and tenant would deny that he is in arrears of rent for the period as asserted by the plaintiff. So, court has to frame an issue whether the defendant is in arrears of rent as claimed by the plaintiff or not. So, on this point, the plaintiff as well as the defendant would lead evidence, and then court has to analyze this evidence and then has to record his finding. So, while recording the findings, the care has to be taken that entire evidence, oral evidence of the parties should not be reproduced in the judgment. The judge, what the judge should do, he has to once again summarize the evidence of the plaintiff, which includes the examination in chief and the cross examination, and then offer his findings on the evidence, and then the conclusion as to whether the evidence adduced by the plaintiff or the defendant is acceptable or not. So, conciseness is the heart of the judgment. Secondly, while writing the judgment, a care has to be taken that the judgments of the higher courts, that is the High Court and the Supreme Court, are properly, uh, if cited before the court, are properly understood and appreciated by the court. Many a times what the judges are doing, they reproduce the paragraphs of the judgments before, which are cited, judgments of the higher court, which are cited before them, which is not the correct way of writing the judgment. What the court has to do is to apply the judgment of the constitutional court in light of the facts brought before him on the record. First of all, the judge has to read the judgment which is cited before him. By reading the judgment, I mean that he has to read the entire judgment, and then he has to find out the ratio laid down by the court in light of the facts and the arguments canvassed before it. So, court has to find out the ratio which is called ratio decidendi. And then that ratio is to be applied in the facts and the evidence which is laid before the court. Merely uh, reproducing the paragraphs of the judgment and at the end to say that this judgment does not apply to the case on hand, or it applies to the case of the on hand, does not serve the purpose. It would not be possible for a person reading the judgment to understand as to how the judge has applied the ratio or the principle of law which the court, higher court, high court, or the Supreme Court has laid down in the facts of the present case. So, understanding the ratio of the judgment cited before the court is also very important aspect of writing a good judgment. Secondly, the the purpose of writing the judgment is to say, uh, to convey to the parties as to why the court has accepted the case of a particular litigant, that either the plaintiff or the defendant, or and has not accepted the case of another party. For that, reasons which the judge assigns is a very important part of the judgment. It is the reasons through which a judge speaks. When a judgment is questioned before the higher court, judge is not made a party to the appellate proceedings, where he can appear and uh, defend his judgment. His judgment can be appreciated by the higher court on the basis of the reasons assigned by the judge concerned. So he should be very clear in expressing his these reasons, the reasons which are recorded should be in light of the oral evidence adduced by the parties, as well as the documentary evidence which is produced in support of the oral evidence. So, judgment, the reasons is the heart of the judgment. Secondly, the as I said, that the conciseness is the very core of the judgment. Lengthy judgments make a, a very boring reading of the judgment. Then it becomes very difficult when a judgment is very lengthy to understand what a judge is trying to convey in the judgment, because there is a very possibility and the likelihood of repetition of the facts and the law which is being discussed by the judge. So when short judgments are there, it is very easy to grasp the point which the judge has made out in his judgment. So preciseness, we should focus while writing the judgment on the conciseness and preciseness of the judgment. Secondly, the while writing the judgment, what care has to be taken by the judge is that mm, the judgment, though the neither the CPC, that is the Civil Procedure Code, or the precedent prescribed any format of an ideal judgment. There is no format for an ideal judgment, but for the sake of convenience and from the judicial pronouncement, uh, we have a practice is adopted in adopting the format of a judgment, which should include, if possible, an introductory part, and then, as I said earlier, the brief facts of the case of the parties, and then the issues. Issues, as I said, should be the points at which the parties are at dispute, they are at variance, they are not admitting the rival assertions, claims of the parties. So this should be the issues, which is, as I said, a very serious exercise which judge has to undertake after by reading the pleadings of the case. So then the format in that, then issue would come, and the arguments of the counsels, advocates for the parties are should be recorded. Uh, Now, what my the experience of the court is that the lawyers tend to advance very elaborate and lengthy arguments. So if verbatim, word by word, whatever they submit is recorded, then there won't be an end, and the judgment would become very lengthy, and irrelevant arguments will also creep in the judgment. So here again, the duty is to summarize the arguments of the advocates of the parties. Important arguments which touches the facts and the law involved in the case should be recorded. While writing the judgment, the author of the judgment should not forget to incorporate the judgments of the higher court cited by the um, advocates for the parties, because many a times what happens that in appeal, an argument is made that a particular important judgment was cited but judge has not considered it. Then it becomes very difficult for the appellate court to find out whether the judgment was in fact cited before the court, trial court, or not. Mm. Of course, there can be some other contemporaneous uh, evidence to show that a particular judgment was cited, but then it is, as I said, it is very difficult. And many a times on such a ground, or matters are remitted to the trial court for fresh arguments and fresh decision. So it should be avoided. The author of the judgment should avoid omitting any important argument or important judgment cited before the before him. Nowadays, uh, lawyers, uh, of course, lawyers are smart, and therefore it is one of the attributes of a lawyer to be smart. But now, what they do after making oral submission, they also give brief summary mm, in writing of their judgment, in which the important bullet points of their judgment arguments are noted, and the judgments of the higher court on which they have placed reliance, so that if the judge ignores or omits to refer to any of the arguments or the judgment cited before him, they can very well point out to the higher court that in fact a particular point was uh, argued and is not considered, and a particular judgment was cited but is not discussed by the court. So one has to be very careful in summarizing the arguments and recording the judgment cited before the court. Otherwise, the judgment becomes vulnerable in the higher courts. These are the some of the attributes of a good judgment, and as it is said that judgment writing is an art and is a science both. Why art? Because I said that one has to first of all write the judgment in a very simple language which is understood by the litigants, not lawyers. They are expert and they will understand the language even if it is a very mm, bombastic or flowery language. But litigants, they are the even laymen who lay person who understand English may not be able to understand the legal jargon. Mm, So we should avoid how to avoid such complex language and legal jargon while writing a judgment is also a very important art. And then why science? Mm, Because the before the trial court, the case has to be decided on the basis of the facts and the law applicable to the facts of the case. Therefore, facts are very important in the trial court. This paid work is done by the trial court, while it is the trial court they are who are doing the real work, because it is the court of first instance. They are appreciating the evidence adduced by the parties. So while appreciating the evidence, which would be, uh, which as I said is an oral as well as the documentary evidence, how to collate it, correlate it, and then find out the mm, uh, truth from the facts and the documentary evidence, which is to be read in conjunction with the oral evidence led by the party. So, and then in light of these facts, judge has to apply the law. It is not other way around that law come first and then facts come. The facts come first and then the law comes. So law has to apply it in the facts before the court. So how to apply it is how to understand the language of the particular section which is applicable to the section of the law which is applicable to the facts of the case is a very uh, serious and complex thing which can be mastered only after a very long experience and the practice. The judge and the lawyers both have to be voracious readers. Continuously, they have to read the emerging, evolving law. Therefore, it is said that once you uh, join the bar as a lawyer or become a judge, thereafter, you become a student of a university called a life university, because then you are a student. You nobody can claim that he is a master of a particular branch of law. Law is not static. It is always evolving. It evolves with the passage of time in light of the socio-economic conditions, in light of the societal changes which are taking place in the society. All these things are directly affecting and impacting the evolvement uh, of law. Therefore, one has to be a very good, I mean, one has to keep the habit of reading the latest decisions of the higher courts, so that he can his mind is trained to be an analytical mind. Analysis of the law and the facts is very important, which can be mastered only by continuous reading. These are the some of the important uh, issues, points which one has to keep in writing while the judge writing a good judgment. Mm, I This is what I have seen as a judge. My tenure as a judge, and before that, be as a lawyer, that verbose judgments are not appreciated by the courts, and they create confusion in the mind of the parties. So we should be a writer of a judgment should be very particular about all the points which I have said while writing his judgment. Second, uh, all of you, I have read the, I have evaluated your judgments which you submitted for mm, this competition, and I am very happy to note this, that most of that all of you mm, have written them in a very simple and uh, lucid language, and none of you have deviated from the issue involved in the problem uh, on which the judgment was to be written. The important thing, winning, I don't, in my opinion, and as said by the director, Dr. Mayuri Pandya, that winning or losing is not important, but participating in a competition is a very important thing. By participating in a competition, one gets an opportunity to express himself. One has to win and one has to lose. That doesn't mean that loser is not uh, has not a good has not done a good job, but the winner has some upper hand, or uh, he has made out certain points in a better way, and therefore he is judged as a winner. Loser should not feel that they have not done uh, their judgments are not good. They are also very good. And all of you have taken, I have seen that very, um, all of you have put in hard work and taken great pains in submitting your judgments for the competition. And I congratulate all of you for participating in the competition, and I wish you all the very best. And as I said, that this is a very good initiative in training the law students to be many of judges. I mean, many students would be hoping to join the judiciary, and this attempt on their part in participating in this judgment writing competition will definitely help them in writing a good judgment if any of the participant becomes a judicial officer. For a lawyer, for those who don't become a judges, also this participation in the competition would be very helpful, because they know the art, the what we can say, the mm, important points which an ideal judgment should contain. So if a lawyer wants to assail a, a judgment of a court before a appellate court, if he knows the ins and out of writing a judgment, then he can very well point out the infirmities which are there, legal or the factual infirmities in the judgment before the appellate court. So a very good attempt on part of the students in participating in this competition, and I wish all of you very good luck and a very bright future and career ahead. I thank the GLS University for making me a part of this competition and giving me an opportunity to evaluate the judgments and address the budding future uh, lawyers and the judges of this country, because the participants are from the different states of the country. And a lot of hope still hinges on the judiciary in this country. People still have hope in the judiciary, and we need good lawyers and good judges uh, to keep our democracy thriving and surviving the challenges it many a time faces from various forces. So, a strong judiciary which consists of lawyers and judges is the need of the hour, and such competitions will definitely produce good lawyers and judges. Thank you very much.
Thank you so much, sir. I hope all of the students have gained a lot of important points for their future, especially those people who would want to pursue judiciary into their future. Sir, I now request you to kindly announce the results in the format of second runner-up, first runner-up, and then the winners.
So, um, once again, I will reiterate it that winning and losing is not the core of this competition. The heart of the competition is the participation. Those participants who do not find themselves in the this result, the first participant or second participant or winner, should not lose heart or hope. Uh, they they have a very good future, and the participation has given them an opportunity to uh, uh, to just an opportunity to gain an experience uh, of writing a good judgment. I wish all of you a very good luck and future. And after analyzing the judgments which were given to me for evaluation, I have found that the second runner-up is VJWC 15 VIT School of Law is the second runner. The first runner-up is VJWC 07 SVKMS NMIMS Kirti P. Mehta School of Law. Congratulations. And and the winner of the today's competition is VJW C24, the Tamil Nadu Dr. Ambedkar Law University School of Excellence in Law, Chennai. Congratulations.
Thank you so much, sir. I would now like
Yes.
to invite the Vice Director of Faculty of Law, GLS University, Dr. Sneha Shukla, for the official vote of thanks for today. Ma'am, over to you. Ma'am, sir, I think there's some. Just a second. Uh, Ma'am,
No, no.
uh, ma'am, I hope we are audible. Yes, ma'am.
Yeah, yeah. Hello.
Yes, I now invite the Vice Director for official vote of thanks. Ma'am, over to you.
Yeah. A very good afternoon to one and all present here. Judgments are not mere conclusions of law, they are conversations between reason, conscience, and society. Good afternoon to one and all present here. As we come to the conclusion of Virtual Judgment Writing Competition 25-26, it is my privilege and honor to present the vote of thanks on behalf of Faculty of Law, GLS University. At the very outset, our deepest gratitude to Honourable Mr. Justice A.G.Uraizee sir, former Judge, High Court of Gujarat, for graciously sparing his valuable time to be the part of this occasion. His enlightening address on judicial eloquence, the art and science of writing judgments, offered profound insights into the discipline, precision, and moral responsibility that judicial writing demands. There is simple yet powerful story often shared in judicial circles. Once there was a young law clerk, and he asked his senior judge how to write a good judgment. So, to which the judge replied, write it in a way that losing party still feels heard. Justice Urazee's address reflected precisely this wisdom. At the same time, it also reminded us that judgments are not only instruments of law, but also expressions of fairness, clarity, and empathy. We are equally honored by his meticulous evaluation of the participants' judgments. His experience, discernment, and thoughtful assessment have added exceptional depth and credibility to this competition. Sir, your guidance will undoubtedly continue to inspire and shape young legal minds. I take this opportunity to express my sincere appreciation to Dr. Mayuri Pandya ma'am, Dean, Faculty of Law, JLS University, for fostering a culture of academic excellence and critical legal inquiry. Her guidance and encouragement remains the cornerstone of such meaningful academic initiatives. How can I forget our dedicated faculty members and administrative staff whose quiet efficiency, coordination, and commitment ensured seamless organization and successful execution of this event? This event would not have been complete without all of you participants. Your engagement with this year's theme, intellectual property rights and constitutional law, has been truly commendable. The depth of research, the analytical clarity, and careful balancing of constitutional values with contemporary legal challenges reflected in your submission speak volumes of your intellectual rigor and promise as future legal professionals. My warmest congratulations to the winners for their well deserved achievement. Finally, I extend my sincere gratitude to our viewers for their attentive presence and encouragement. Your engagement reinforces the importance of academic platforms such as this in shaping informed, responsible, and reflective legal discourse. Once again, I thank everyone who contributed directly and indirectly to the success of this event. I conclude with the words of Justice Benjamin Cardozo: the judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. May this competition continue to remind us that the art of judgment writing lies in disciplined freedom, thoughtful restraint, and unwavering commitment to the justice. Thank you.
Thank you so much, ma'am. And I again thank sir for joining today and sparing his valuable time. Thank you so much, sir.
Thank you.
Thank you, ma'am.